This conference will now be recorded.
Okay, so with that, I'm going to turn it over to John Howard Society of Canada board member Zilla Jones, who's going to be moderating this panel. And I look forward to hearing all of the interesting information that's going to be shared today. Thanks. Enjoy the session.
Good morning / afternoon, everybody. It's great to be here with you for John Howard Week. And I'm just going to acknowledge the land. So I am a member of John Howard Society of Manitoba for the board of directors for John Howard Society Manitoba, as well as for John Howard Society Canada. I'm also a criminal defense lawyer, and I live and work in Winnipeg, which is Treaty 1 territory, original lands of the Anishinaabe, Cree, OG Cree, Dakota, and Dene peoples, and it's the homeland of the Métis Nation, and our water is sourced in the Shoal Lake 40 Nation. I understand we also have individuals joining us on the panel from the city of Toronto. That is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is included in the Dish with One Spoon Treaty. And so is Kingston. We also have somebody from Kingston, which is on Anishinaabe and Haudenosaunee territory as well. And then we have Calgary and Edmonton represented. Calgary is Treaty 7, the traditional territories of the Blackfoot Confederacy, the Métis Nation, and Edmonton is in Treaty 6 territory, and also the Métis Homelands and Métis Nation of Alberta Region 4. If you guys are in other territories, you want to throw that into the chat, you can do that, and we can acknowledge them through the chat. So today, we have 3 speakers with us. It has been more than 25 years since the Arbor Commission pointed out that the rule of law does not operate behind prison bars. Madame Justice Arbor stated that it would require other components of the justice system to ensure that the rule of law is respected within our prisons. So this panel will explore the extent to which criminal law can be a tool to address abuse behind bars and promote respect for the rule of law. The panel will look at certain criminal code provisions that might be violated in prisons, how these can be fairly investigated, and what standards need to be met for correctional officials to be held criminally responsible. And so we invite a discussion on whether the criminal law can be a tool to curb abuse of prisoners and lead to changes in correctional practices. And so I put the longer bios of our speakers into the chat so you guys can read it there. And I'm just going to give you a summarized version of their bios. So we have Lisa Kerr, and Professor Kerr teaches courses in criminal law, sentencing, and prison law at Queen's Law School, and also serves as the director of the criminal law group at Queen's Law. And she has worked for several years with the Pivot Legal Society on a campaign to decriminalize sex work. She has worked with the BC Civil Liberties Association and the John Howard Society of Canada on litigation that we undertook to abolish solitary confinement in Canadian prisons. And she also supports strategic litigation work at the Queen's Prison Law Clinic. We have Tom Engel. Tom has been a member of the Criminal Trial Lawyers Association for many years and has been on that board, and since 2000 has been chair of the Policing Committee. He has worked hard to improve the state of policing and civilian oversight of police with the Edmonton Police Service, the Edmonton Police Commission, the Solicitor General, and others, holding the police to account through the Police Act, the RCMP complaint process, and chartered offences and criminal prosecutions. And also we have Shane Martinez, who regularly writes and lectures about police brutality, racial profiling, the prison industrial complex, and transnational labor. He works closely with Justice for Migrant Workers, and that provides legal assistance to Caribbean and Mexican migrant farm workers in Southern Ontario. He is the founder of Martinez Law, which combines a social justice perspective and innovative legal analysis, and he has been counseling coroner's inquests for people who have been killed by the police or died in jail. He is also the Deputy Legal Director at LIUNA Local 3000, which helps defend the rights of Ontario frontline healthcare workers. So please welcome our speakers. They're each going to present for about 15 minutes. Lisa Kerr is going to go first, and she will explain the criminal code provisions that could be violated in prisons and what the implications are in a correctional setting. Then Tom Engel is going to talk about the challenges of investigation into these allegations, through ombudsmen or through other potential bodies. And then Shane is going to talk about the level of proof we would need to find a criminal offense involving criminal authorities and perhaps address why so few charges are laid. So I'll turn it over to them. If you guys have questions or comments, you can put them in the chat and then I can pose those for you at the end, or you may have the opportunity to ask them. But for now, I'll turn it over to Lisa Kerr.
Thank you so much for that, Zilla. And thanks to the John Howard Society for drawing our attention to this important topic today and setting up this session. My role is to give a general outline of possible pathways to criminal liability in situations involving misconduct by correctional officers. And we've been asked by Catherine Latimer to consider 3 offenses specifically. So first, failing to provide the necessaries of life. Second, excessive force. And third, torture. I see that it's mostly lawyers on the call today, although perhaps not all criminal lawyers. So hopefully my presentation is sort of pitched at the right level, help us all get on the same page in terms of the basics of these offenses. So I'm going to start with what I consider to be the most plausible pathway to criminal liability, and I'll end with the least plausible and make a brief comment on prosecutorial discretion. So I start with section 215 of the Criminal Code, which makes it an offense to fail to provide the necessaries of life in certain circumstances. Now, first, who does this provision apply to? Not just anybody. It applies to people in particular relationships of dependence, parents, spouses, and the section is clear that correctional officers do have a duty to assist under this provision. They have a duty to provide necessaries of life to a person under their charge who is, by reason of detention, unable to provide for themselves. Second, what kind of failure qualifies under this section? The failure has to either endanger the life of the prisoner or cause or be likely to cause the prisoner's health to be permanently injured. Those are the consequences that have to be on the table. In terms of the fault required, you have to look to the case law for that. This is an objective fault provision. It's not about what an accused actually knew or intended. And I think that's part of what makes it a plausible pathway to conviction, because evidence of subjective intent can be really challenging, especially in this context. So it's not going to be a defense for a correctional officer to say, who fails to deliver insulin, to say, I didn't know the prisoner's kidneys could be damaged. I didn't intend that. That's not a defense here. All the Crown has to establish is that the harm was objectively foreseeable, that a reasonable person would have known that the failure could lead to those risks. So I think that would be pretty straightforward when it comes to something like the need for insulin. The Crown would also have to show that the actions of the correctional officer were a marked departure from the conduct of what a reasonable correctional officer would have done in that circumstance. So here you need evidence of how a reasonable CO would behave, and that would be drawn from perhaps training standards, policies, expert evidence, and so on. And I think here you do have to expect some leeway for the correctional context, what was going on at the time, the pressures they faced, the needs of other inmates, staffing levels, and so on. The analysis is of a reasonable CO, but one that was in that circumstance. So one final note on section 215, if a CO fails to provide the necessaries of life and it results in death, that could lead to a charge of criminal negligence causing death, section 220, or 221 if the result is bodily harm. Criminal negligence was the charge initially laid against the officers who stood watch while Ashley Smith died. Criminal negligence is a more serious offense than 215. For that reason, it has one additional piece to it. I mentioned that 215 requires the marked departure of what a reasonable CO would have done. Criminal negligence has a slightly elevated standard. It requires a marked and substantial departure. So, as we all know, the prosecution of the Ashley Smith officials did not continue past the preliminary inquiry stage. I don't know exactly why, but my sense was that once the evidence came out about the officials being under orders not to intervene that day, Perhaps the Crown thought there would be doubt about whether their conduct, right, which is following that order not to intervene, would have been a marked and substantial departure. So this last point, I think, helps to remind us that criminal liability, even for an objective fault crime, requires significantly more of a departure from the standard of care than a civil claim based on the same misconduct. So I can be much more brief with the final two offenses. Excessive force, which could lead to assault or perhaps manslaughter if death is the outcome. The test for whether force is excessive looks at two factors. And once again, it's important to identify the subjective and objective elements. So first, a court would ask if the officer had a subjective belief that the force was necessary in the circumstances to maintain custody and control of the inmate. So that's looking at what did this officer believe to be necessary in the circumstance. And my guess is that on this factor, most COs would have a pretty easy time showing their subjective belief that it was necessary. But second, the subjective belief has to be objectively reasonable. So here we get to step away from the individual accused and assess the reasonableness of their belief. So there you would take a look at the situation, what they were facing, what the victim was doing at the time, and so on. And I'll refer you to one case I found interesting on this front, Rowan from the BC Provincial Court in 2013. The facts of this case, the accused was an experienced supervisor. He arrived on a scene where an inmate was already being held down by between 4 and 7 other guards and had already been pepper sprayed. Now, the other guards were calling out, "Stop resisting," although there's been some discussion about whether that's sort of a tactic to justify further force. The accused arrives on the scene and very quickly delivers a number of kicks to the inmate. Now, this case was well litigated. It had an extensive record. There's video of the incident. The accused testifies, several other COs testify, there's experts on both sides. The Crown expert concludes that the force was not called for. The inmate was passive, didn't have weapons, had no means to cause harm, was not assaultive at the relevant time. Now, on the first branch of the test, the court had no trouble concluding the accused had the subjective belief that force was necessary. And as I said, I think that's going to be an easy one for most accused. In this case, he had just arrived on the scene. There was no evidence he had other motives, so he had this subjective belief. The case turned on whether that subjective belief was a reasonable one. And here, the court cites case law, drawing from the police officer context, but it applies here, on the need for latitude. The court said that officers are under a duty to act, and they must often react in difficult and exigent circumstances. The court said they should, quote, not be criticized unduly for making immediate decisions in the course of duty, which, when analyzed with exquisite precision after the event, may not be demonstrated to have been the most appropriate decision to have made. So when a court is citing passages like that, you get ready for a conclusion of not guilty, and that was the conclusion there. And I think with those quotes, it does indicate that the court does grant a measure of deference to the correctional context when analyzing the reasonableness of a view that force is necessary. Now, just one important comment about Rowan. This case had video evidence of the key events, and there are so many other cases, and I know Shane and Tom will speak about this, that don't have the benefit of that evidence. So in the case of Solomon Fakiri, there's no video of the crucial moments. And then add to that a code of silence, a fear among witnesses, and so on. And you have very challenging evidentiary issues in these cases. My final short point about the offense, here I've been asked to comment on the idea of using section 269.1, the torture provision. And I think here we're at the least plausible pathway to liability. I can understand the thinking behind the idea. You know, we have some constitutional holdings that 22, 23 hours a day in a cell is torture when it extends beyond 15 days, perhaps sooner when it's used on people with mental illness. We know, of course, that this form of confinement has been very widespread in the pandemic especially. But I think the concept of torture that's developed in the Section 12 context can't just be transposed onto the criminal law context. So I think for the offense of torture, we have to look at what the code says, and a conviction would require proof beyond a reasonable doubt of intentional infliction of severe pain and suffering, and that treatment was imposed as punishment. Prosecutions under this section are exceedingly rare against anyone. I think the factual matrix for the prison context would have to be really severe. I do not think COVID lockdowns would qualify. I think the prison could just easily say they're not imposed as punishment and point to staffing challenges, outbreak management, and so on. So for those issues, I think constitutional law and class actions remain the right path. Now, just one final point. As we all know, the Crown decision to prosecute is governed by two factors: the public interest in the prosecution and a reasonable prospect of conviction. And those two factors are no different when you're involved, when it's an accused is a correctional officer or a police officer. Those are still the two factors, certainly in Ontario, and my guess is in every province in the country. Now, my guess is that these kinds of allegations would be taken very seriously by many crowns, and that many crowns would appreciate the strong public interest in ensuring that people in positions of power are held to account. I also think, though, that the implications of prosecution would be taken seriously in these kinds of cases, and that crowns would factor in, just as courts do, that the work takes place in a difficult environment. The Crown and investigating police agencies likely want, more than in any run-of-the-mill case against an individual, to see that the charges are very well-founded and likely to succeed at trial. There would be layers of review to the decision, right, which would be distinct from other kinds of decisions to prosecute. My guess is there would be very little appetite to lay charges if there's any ambiguity about the conduct. So with that, I'll pass it on to my colleagues who have far more experience actually working on these kinds of cases.
Before we move on, does anyone have any questions on that? I see actually there's one in the chat. Regarding excessive force, when a guard is charged, if a prisoner isn't provided the name of the guard charged, where should we look first to find that out? Any comments on that?
Well, I can comment on that if you want. Can you hear me?
Yeah, go ahead.
Oh, okay. Okay. Well, you just do an ATIP or a Freedom of Information request and you'll get the names.
Okay, thank you. Any other questions on the criminal code sections before we move to Tom? Okay, so I guess we'll move on to Tom, and Tom's going to talk about the difficulty of these prosecutions.
I'm going to talk about the difficulty in relation to the investigation of criminal complaints. But I do want to comment briefly on what Lisa said about the Prosecution Standard, which is reasonable likelihood of conviction in Alberta. This is a real big problem, and in Alberta especially, probably everywhere. But what Lisa is talking about there is really a double standard, that the Crown looks very carefully at prosecutions against jail guards and police. What they do is, okay, so first of all, you have to have reasonable likelihood of conviction. If you have that, then you turn to whether it's in the public interest. If there's no reasonable likelihood of conviction, it's over. But if there's a reasonable likelihood of conviction, then you look at the public interest. And I can't imagine how it would not be in the public interest to prosecute a police officer or jail guard who's committed a criminal offense, even if it's minor. All you have to do is look at prosecutions of people for assaulting jail guards or for assaulting police officers. There's a clear double standard at work here, and this is a major problem. But again, I'll shift back to my topic, which is investigations. So and I'm not going to talk about the ombudsman, because in Alberta, the ombudsman is just a toothless entity, doesn't do anything. Compare that to the work that the Ontario ombudsman does, and it's like night and day. So it's worthwhile making a complaint to the ombudsman, the provincial ombudsman in Alberta. Sorry, it's worthwhile making a complaint to the ombudsman in Ontario, and also to the federal ombudsman, who is the correctional investigator. But it's a negative experience if you do it in Alberta. If first of all, you have to exhaust the chain of command within the provincial jail, and all the guards find out, including the ones you're making the complaint about, and you get retaliation. And then when you eventually get to the ombudsman, it's a paper review, and they'll say something, oh, they're just following policy or something. And then the prisoner faces retaliation for doing all that. So I tell my clients, don't even bother. It's just going to make the situation worse. So and internal investigations by CSC, they're not really transparent, given that nobody ever seems to get fired in CSC for using excessive force. I would presume they're corrupt, the internal investigations, and there's simply no transparency. I don't really know what goes on with those things, but I do know that they have internal investigations. In terms of the correctional investigator, the correctional investigator makes really insightful reports, recommendations, and then nothing changes. I've been urging the correctional investigator for years to use the power to hold a public inquiry into the situation at the Edmonton institution, otherwise known as the Edmonton Max. There was a major criminal investigation by the Edmonton Police Service and jointly with the RCMP into criminal conduct at the Edmonton Max. It yielded one prosecution. That was a sexual assault by one jail guard on another jail guard. And eventually the Crown stayed that prosecution. Not one charge of excessive force arising out of the Max. My conclusion would be that the breakdown was either at the investigative stage, where the police conduct corrupt investigations, and I don't use that word lightly. And then when it goes to the Crown, they apply their double standard and find that there's no reasonable likelihood of conviction. There's no transparency to this. There's no clear statement made by the Alberta Crown, as in BC, about why there are no charges. You never find out what the details of the investigation were, but to have that major investigation produce no charges just shows me that there was something corrupt about the process, either at the investigative stage or at the prosecution stage. Now, I've talked to some people who are in the know, and I suspect it's at the prosecution level. And I think there were some pretty good investigators involved in that, and I think they're pretty pissed off about all that work going nowhere. So what I do is I do this on behalf of clients. I make the complaints on behalf of the clients. I make them to the correctional authorities. I cite their policy. I tell them exactly what they have to do in the investigation, like, for example, interview prisoners who were witnesses. And if they don't do it, I tell them that this will be a matter of record and it will be raised in court someday, either in the defense, say a 24-1 application for cruel and unusual treatment. So in the defense of a person on criminal charges that land him or her in the remand center, or in a lawsuit, or perhaps even something that's percolating out there is an application for a sentence reduction by the sentencing court. But I'm very clear on what my expectations are for a proper investigation. And I have lots of policies that I can cite, and I can tell them I can cite those policies. And if it's an internal investigation, so let's say I make a complaint to the director of the Edmonton Remand Center, I cite their policies and I tell them they must strictly follow their own policy. And then what they do is they go ahead and don't follow it. And then that becomes part of the record if you ever raise this in court. So in relation to criminal complaints, so the complaints have to be made to the police. And I recommend to my clients that I make the complaint for them. And I lay out the details of the complaint, my expectations of how they should investigate it. And then when the police don't do their job, when you can see that there's been a corrupt investigation. And so in the case of a remand prisoner, for example, when you raise a charter breach about the underlying criminal offense by the jail guards, you're going to get full disclosure of that in the context of defending the prisoner. And if it doesn't get to a trial, then you're going to be able to get it by FOIP. So once it appears to be reasonable to complain about the investigation itself, then I make Police Act or RCMP Act complaints on behalf of the prisoner. And our office is relentless on this. We will always make complaints of negligent investigation, biased investigations, corrupt investigations. This has borne some fruit with the Edmonton Police Service. So the Edmonton Police Service has this unit called the Institutional Investigation Unit. And it's sort of a warehouse for bad cops. Cops who are bad at their job, have run into disciplinary problems, so they just shift them over into this unit and figure, well, we'll just have them investigate complaints against jail guards, which is ridiculous. They should have the best detectives in that unit. And I've complained about that. I've raised complaints with the chief that he is putting people in that unit who shouldn't even be cops, let alone investigating something like this. And I cite their disciplinary histories because the CTLA Policing Committee has a database on bad cops. So I say it's borne some fruit because finally the chief of the Edmonton Police Service has decided enough is enough, and he's had detectives retire. So there's a loss of Police Act jurisdiction. He's had detectives retire to evade discipline. He knows what's going on, and now there is an overall review of that whole unit. And the CTLA Policing Committee, me as chair, and Amanda Hart-Dehoon, the president of the Alberta Prison Justice Society, has been notified of this, and we're awaiting the outcome of that. Hopefully, there will be a major improvement. So I've provided a couple of redacted documents. It's in the chat to show you what my tactics are. And I'm looking for accountability of police officers for failing to do their job. And I'm looking for an overall improvement in policing so that prisoners can expect to have an independent investigation with integrity of their complaints. Let's not underestimate how important that is to a prisoner. The fact that a prisoner will make a complaint internally to Alberta Corrections about his or her mistreatment, and it's they know a corrupt investigation when they see one, and it goes nowhere, and all they get is retaliation, maybe a few beatings here and there. The fact that they know that jail guards know that they can act with impunity, nothing is going to happen to them job-wise or criminal prosecution-wise. And this, Michael Jackson testified about this in a case called Trang that I did, was reported in 2010, Alberta Court of Queen's Bench. So Michael Jackson testified about this. He testified that this produces hopelessness and anger in prisoners. They're supposed to learn in jail to respect the justice system, to respect authority. They learn exactly the opposite. They get out of jail and they are angry and bitter, and they have contempt for the justice system. It's so important. If you look at the Mandela rules, I think there's a section in there about how one of the rules is to have an independent investigative body to investigate prisoner complaints. And so that is my mission, I suppose, as a criminal defense lawyer and chair of the CTLA Policing Committee. I'm also, this wasn't mentioned, but I'm also president of the Canadian Prison Law Association. This is on the radar of our executive. There's a case of a prisoner who was on dialysis at the Bowden Institution. And when COVID came in, they didn't take him out for his dialysis. He died. And as a result, and so we're going to be making a fail to provide necessaries of life complaint. I'm working on that. I've got lots of letters from prisoners there about it. But we'll see how that goes. That'll have to go to the RCMP. But I don't know if I would rank this up in the high part of our mission to do something to improve the lot of prisoners. So let me see here, just checking. I'm kind of rambling a bit here. Sorry about that. If you want to use the precedents that I've provided there, you know, as the basis for letters that you might want to write, please go ahead. So, I think that's what I have to say at this point.
Zilla, I don't think we can hear you.
Yeah.
Or at least I can't.
Yeah, I can't hear her either.
Zilla, you don't look muted, and yet we can't hear you. Should we just pass the mic to Shane in the meantime? Okay.
Okay, I can do that. All right, there we go. I got the go ahead. Okay, so thanks a lot, Zilla, and thanks Lisa and Tom as well. I'm also very thankful to the John Howard Society for the chance to speak aside Lisa and Tom. It's definitely an honor. I'll be addressing, I guess, the question of criminal convictions of correctional officers a bit more broadly. And what I'm going to do is I'm going to try and share my screen here if I can. Let's see. All right, I think we've got this going now. So yeah, I guess, you know, as we know, criminal charges against COs, they don't seem to be commensurate with the number of complaints that prison lawyers receive about excessive force and other forms of abuse within institutions. So I'm going to try and look at why this is and why there are so few convictions flowing when charges are in fact laid. Now, in order to do this, I'll review decisions where COs have been found guilty, but also a couple of them where they haven't. We'll also look at comments from the bench as well on sentencing a convicted CO. And to close off, I'll take things in a bit of a different direction with a strategic discussion about considerations that prison lawyers may want to have when they're representing an inmate who's reporting allegations of excessive force or abuse. So at the onset, I guess I'll say that there's not a wealth of case law to draw from where COs have been found guilty of any criminal offenses, but in particular ones involving physical harm to an inmate. So for example, assault or other abusive behavior against inmates. More common, it seems, are cases where COs have been caught smuggling drugs into jails and prisons, but that's kind of a topic for another day. I've drawn a sampling of trial and appellate level decisions from different jurisdictions for the purpose of today's discussion, and I've attempted to identify some of the reoccurring factors, which I'll delve into after looking at these decisions. So, although there were some civil cases where inmate credibility was drawn into question automatically by virtue of their position as prisoners, this isn't something that particularly stood out in the cases that I reviewed, keeping in mind that, again, it was a limited selection. In the Saskatchewan Court of Appeal case of the Queen and White, possible credibility issues were actually not a hurdle where the victims appeared to testify, but the accused CO did not. Now, the court simply worked with what they had, and even though there were some issues about whether or not stories lined up with timelines, the Court of Appeal didn't find that the credibility issues on the part of the inmates, if any, were significant enough to overturn the conviction. Now, in most cases, however, the accused CO does testify. Now, this, of course, can be a double-edged sword where the accused has previously given a statement. Contradictions and discrepancies between an accused CO's statements can help level the credibility contest between a CO and an inmate. And that's what we saw in the Queen and Healy from Quebec. And that case kind of shows us the importance of institutional investigations as well, and records from those in the event that a matter proceeds to trial. Healy is also an example of how important the testimony of so-called, I guess we could call them neutral observers or fellow officers who are going to give honest testimony can actually be. Now, as we get into more recent decisions, we see the increasing role of video evidence. Now, that was the case in the Queen and Crocker in Newfoundland. A lot of these cases seem to come out of Newfoundland for some reason. I have no idea really why that is. Maybe there's more instances of it happening there, or disproportionate instances, or more of a willingness on the part of the Crown to pursue the matters. Whatever it might be, what we saw is in both Crocker and in the decision of Roach, which I'll get to in a moment, that in both of those, video evidence featured quite prominently. Now, I can personally say that I've had 2 cases of alleged inmate on guard assault dropped after I've pursued institutional security video. One showed that there was never an assault whatsoever. It was purely a fabricated allegation. The other showed that it was in fact the guard who had beaten the inmate. Now, sometimes video evidence is not quite enough, though. The Crocker case was widely reported in Newfoundland, and the video of the incident was obtained by the media, and it can be found online. Although the inmate had been a bit cantankerous and abusive earlier in the video, at the time of the alleged assault, he was laying in a prone position on the floor. Now, in that case, the officer relied on Section 25 of the Criminal Code as justification for his conduct. In other words, he was asserting that as a correctional officer, he was, by virtue of his role, acting on reasonable grounds and justified in kneeling on the inmate and using as much force as was required, which he felt required multiple punches to the individual's face to carry out his duties in removing the person from the cell. Now, the trial judge didn't accept that, but an appellate judge apparently did and sent the matter back for a new trial. Now, unfortunately, I was unable to locate the appeal decision. Ultimately, though, the Crown reassessed whether there was merit in proceeding and concluded that the case simply was not strong enough, again, despite the significant viva voce evidence and security video. Now, so from these and other decisions, or I guess maybe a lack of decisions, there's a few things that we can identify. But before we jump into those, I just want to touch on 2 cases having to do with the failure to provide the necessaries of life. There's not a lot of reported decisions. Again, here we have 2 from Newfoundland. In one of them, 9 correctional officers were charged following a fairly violent altercation with an inmate there. We see significant failings by the Crown in that case, where the Crown offered no evidence whatsoever about the standard of care of a reasonable and prudent correctional officer. Now, the court ultimately said, well, I can gather that from other facts that have been introduced into the case. I don't need to have, expert evidence about that standard of care. But I think what we see is how crucial that would have been, and how much that could have potentially guided the court in the decision of Cody. And so ultimately, though, there was no admissible evidence upon which a properly instructed jury could convict. And at the prelim stage, all 9 officers were discharged. There's also the decision of Devereaux as well. And that was one where an individual was brought into a lockup in St. John's, Newfoundland. He was in a state of obvious distress, according to the trial judge. But ultimately on appeal, it was found that the trial judge erred in terms of failing to find beyond a reasonable doubt that there was an objectively foreseeable risk, or that it was objectively foreseeable that a failure by these officers to provide medical assistance would pose a risk of danger to his life. Of course, 2 different ways of looking at it, but the appeal judge had the final say on that. The appeal was allowed, and a verdict of not guilty was substituted. So I guess looking at some of the things that we draw from these cases and other ones that I had a chance to go over again, just keeping in consideration the limited time that we have. First, I think, a relevant factor in obtaining a conviction is the willingness of the police and the Crown to lay and pursue charges in the same manner that they would if the complainant was not imprisoned. Second, honest testimony from COs is imperative. There were cases reviewed where the court remarked about how officers had effectively told one another not to cooperate. Third, security video is often critical and needs to be preserved. I'll talk about that more in a moment. It's not always determinative, though, as we saw in the Crocker case. Fourth, as well, medical records of a prisoner, institutional or otherwise, are important to substantiate the degree of the alleged assault. Fifth, contradictory statements made by an officer after an incident. Those can be of quite significant importance, again, when it comes to leveling that credibility contest. And finally, credibility and demeanor of a victim is always important as well. Really briefly, I can tell you, I represented an inmate in a civil case where there was clear video of him being pummeled by guards at the Toronto South Detention Center. The civil matter settled very much in the client's favor. However, at a criminal trial, the guards were so argumentative and the client was so argumentative and objectionable in his testimony that he somehow overshadowed what was really clear and obvious video about the assault, and the 2 officers were found not guilty. I think had he presented in a different way, that certainly there could have been a different outcome there. Now, these are the last few slides with just some words from the bench about what's to be considered when, I guess, sentencing a CO. And I think this is important. Again, it can help guide us in some of our work in this area. We see that relevant factors in sentencing include the vulnerability of victims who are prisoners and the need to provide safety, the authority and position of trust held by a CO, and the need for public confidence in the operation of prisons and jails. Now, while some judges are, I guess, possibly swayed by supposed sterling records and character references of COs who come before them, others are not, as was the case in Corrigan. The court called the offense what it was, labeling it a reprehensible crime in a free and democratic society, calling it also a crime against the justice system itself. That was also the case in the decision of Rosa, where the judge went even further, calling out the tendency to disbelieve prisoners' complaints about abuse, which was quite an important comment to put. The court went on to say that prisoners are in a defenseless position and they have to be protected against assault and excessive force, and that having a difficult job is not an excuse for abusing a vulnerable person. And finally, I'll just wrap it up with a few comments about considerations that counsel may want to have when representing inmates who have been, who have alleged to have been assaulted or abused, or ones that are alleged to have assaulted or attacked guards. So I would say, it's always really important to try and get a detailed narrative from the client as early on as possible: who, what, when, where, why. If you can get audio or video recording of the client, that's even better. If you, for example, if they're in the hospital, if they've been attacked, sometimes it's possible to get photos or videos of them if you're able to meet with them in the hospital. You can also describe a client's visible injuries on the record in court as a way of trying to, again, create that record of what had happened. You also want to try and track down any potential witnesses to the assault, identify their counsel if they're inmates, and try to make arrangements to speak with them. You can also send a preservation request letter to the jail or prison. It's imperative that that happen as soon as possible. As retention periods, they vary depending on the institution, and the potential evidence could disappear by the time you put in an FOI or ATIP request, which is of course the next step. And if you have a civil matter, you may wish to pursue copies of employee records relating to warnings and discipline. Those kinds of things don't usually show up in a McNeil report in criminal cases. So if you're actually defending someone who's been accused of assaulting a guard, be sure to expand your disclosure request accordingly and seek those records as well. And I guess finally, although the parole board manual doesn't make specific reference to someone being abused in custody being a consideration when determining release, you may want to consider if you're able to use that information to present your client's experience before the board in a way that might help garner a favorable outcome. So again, we're just scratching the surface here, but if you're so inclined to gather the stats and case law necessary for a more deep comparative analysis, I'd encourage anyone to consider maybe doing a research paper on this subject, because it's certainly an area that warrants further investigation. Thanks very much.
Thank you, Shane. Can you guys hear me now? Yeah, okay, great. I'm not sure what's going on. Shane, we had a question about people wanting to know if they can see these slides. So are you willing to share those maybe with Ria or Catherine, and they can send them out to the attendees?
Absolutely, yeah, I can send those out right after we're done.
Great, because those are very helpful. I certainly would appreciate having those as well. Do any of the attendees have any further questions for our panel? I do have one that was suggested earlier. I'm just going to open that up. Sorry, give me 1 second here, guys.
Well, this is Leah, and I have a question.
Okay, go ahead.
Particularly for Lisa, I was wondering, because you said that you think that charter and class actions are probably more effective avenues for addressing torture within prisons. And I'm just wondering what your thoughts are in terms of, because the class actions and charter challenges that have happened thus far, which have acknowledged that torture is happening within prisons, haven't actually been successful in stopping that torture, which is why I think, particularly for me, an interest in criminal liability and how that could potentially prevent that type of behavior from happening is sort of an interesting way to think about it. So I'm wondering if you have any thoughts about how, if not using the criminal code to prevent torture from happening in prisons, are there any other strategies that you could maybe think of that would actually put an end to the torture that's happening?
Yeah, I definitely understand and appreciate the desire to develop strategies that on the enforcement end are effective. I think, I mean, in my comments, I did try to sort of say, I'm not sure, maybe others have view on that. I haven't thought of it for a long time, but I'm not sure that we can take the court, let's take the Ontario Court of Appeal, for example, in the solitary confinement case, right? Justice Bonatto does determine that 22, 23 hours a day in a cell beyond 15 days constitutes cruel and unusual punishment under Section 12. I'm not sure that we can say, that's the meaning of torture, and so that if you do that to anybody intentionally, that is an offense according to 269.1. That's my point, is that only the criminal code sets out what is an offense in this country. That's the source of criminal liability, and so we need to go to that section. And I even though the word torture is in both places, and I know the origins of the provision, there's some ties there, but I'm just not sure that that what is happening in terms of the failure to meaningfully bring an end to 22, 23 hours a day in a cell pursuant to constitutional rules in the area is the same as committing that offense under the criminal code. And I mean, Leah, on the bigger question, this is something we always talk about in my class, you know, have things gotten better on the solitary confinement front, or do we just have solitary by another name now, right? We struck down the administrative segregation provisions, but now we just have structured intervention units, nothing new under the sun. And, you know, my take on it was that the legislation is better now, right? It at least lays out better norms, even if, right, adhering and enforcing those norms, we haven't gotten there yet. But, you know, when I look at the Dube and Sprott reports on these issues, you know, I see that in some parts of the country, they're doing better than other parts. And some parts of the country, they are getting inmates out of their cells for the legislative minimum hours. And some parts of the country, they are absolutely in breach on a regular basis. And so I think what we draw from that is that enforcement is possible, but you have to go pick it off one by one. And, you know, the great tragedy on solitary confinement is that after, you know, 20 years of everyone working on this issue, there's finally success in the courts, and then we run into the pandemic. And there's this new justification for locking everyone down over these last couple of years. And so it's a tough battle, and it's one that was significantly set back. But I do think that the constitutional litigation class action front has been successful. But prison law, you don't just win in court and then the next day the prison behaves perfectly. Prisons constantly breach and constantly need oversight and enforcement.
Thank you
Here's
so
a
much.
question. Oh, thank you. I found the question that was asked earlier. So given that there's been difficulty with charter cases and civil damage awards getting correctional authorities to change their ways, do you think that if we use individual criminal liability, that process will lead to less prolonged solitary confinement or less problems with use of force incidents? So will the threat of prosecution have any impact essentially upon correctional authorities? Tom, do you think that would make a difference, even if they're not convicted, if they know that they can be charged and go through that process? Will that make them less likely to engage in force with inmates and those type of things?
Okay, absolutely. And this is what I mentioned about these guards thinking that they can do this sort of thing with impunity. If they know that they can't, and there's a likelihood that they'll be held accountable, the criminal law is supposed to deter behavior like this, so it would have. Now, damage awards, they could care less about because they're not paying for it. The state pays for it. And the state has a bottomless fund.
Yeah, exactly. For everybody who was asking about the slides, they are now available in the chat. And Shane's also put his email there. So if you have any difficulty downloading them, you can email him as well. I do see another question has come in. I'm not sure how much time we have left, but maybe we can get to this one. That basically there's been a lot of complaints with COVID-19 about how lockdowns have been used with access to showers, visits, and that type of thing. So do you think it's possible to go back to the same movement that we had at the beginning of the pandemic, where there was an increased move to rapid decarceration to get people out of those risky areas? And how can we achieve that mass rapid decarceration that we were using at the beginning of the pandemic? Does anybody want to tackle that?
Well, I mean, I would just throw in there that, you know, at a federal level, there was no intentional mass decarceration. You know, federally, there was a massive reduction in admission of court closures, and that led to the equivalent of 7 empty penitentiaries, the correctional investigator tells us. So, but that wasn't intentional. That was an outcome of court closures.
Some of the provinces did intentionally do that, though. I know certainly we had intermittent sentences which were then not being enforced during COVID, or if the judge was kind of on the line about jail or not jail, they were doing not jail because of COVID and that type of thing. And I know the test for bail included COVID concerns. So I think provincially there was some of that. So I don't know if that is able to be addressed after.
Well, and I think that even in the provincial level, at least in Ontario, I do think that folks who weren't getting bail before the pandemic are getting it. But you know, you also see a lot of courts say, oh, well, I'm not too worried about custody for you as long as you don't have some profound individual vulnerability. Tom litigated a case called Harrington early in the pandemic where he was able to succeed, but his client had these profound vulnerabilities health-wise. And then some judges picked up on that and sort of said, you know, that's the standard, right? And if someone seems to have good underlying health, then we don't have to worry so much about sending them into custody. So yeah, it's a good question the speaker asked about, you know, how do we get back to those early reactions to the pandemic where judges were extremely concerned about sending people into especially pretrial custody, and where the provinces made a really dedicated, several provinces, as you say, made a really dedicated move toward lowering their populations. I feel like we've now gotten a little desensitized to some of the risks that are probably worse than ever in many jails and prisons right now.
Thank you for that, Lisa. Oh, what happened to the line guard, Shane? Are you able to tell us?
Ask, which case? There's so many.
Well,
Tom,
that's my question. You said that it was found that the guard had fabricated the allegation that he or she was assaulted.
Oh, that one, yeah. That one, what ended up happening is that I had brought a, oh no, so there were the two. There was the fabrication one, and then there was the one where the person had actually been assaulted. To the best of my knowledge, nothing ever happened to the guard who fabricated the assault allegation. He had claimed that my client had attacked him after he had hung up the phone. And when we got the security video, the client hangs up the phone and they walk in separate directions. There's never any engagement between them. I think there was maybe like some words exchanged, but yeah, to the best of my knowledge, nothing happened. With respect to the other one, where it was actually the guard that assaulted the client, I had brought a charter application after we got the security video. The Crown then proceeded to drop the charge, and whatever happened to that officer, I'm not sure either.
So this highlights something I was talking about, the importance of making complaints. And what I do is I get an instruction from the client in both those cases, and it's never too late to make a criminal complaint. So one is public mischief, you know, making a false complaint, obstruction of justice, assault, and if complaints were made, then you know something might happen. But I always tell clients, if you don't complain, you can be sure nothing will happen.
Yeah, it looks like there's...
And just to add to that, if I may, that Crown prosecutor, the Crown prosecutors in both cases, they know exactly what happened. They know that these guards committed crimes. They have a duty to do something about it, and they almost never do.
Yeah, while all of you were speaking, I really, it just occurred to me how different the standards are for accountability, how we send people to jail to become accountable. They learn the opposite. I know at least in Manitoba, when we do pre-sentence reports, one of the first questions that clients get asked on their pre-sentence report is, do you feel the justice system is fair? And do you have respect for authorities or something like that? And of course, the clients often don't, and we have to tell them, you know, like you have to kind of lie, right? In this pre-sentence report, like you cannot go into the stories of what happened, because then they will say you're antisocial, you're not suitable to be supervised at probation because you don't respect authority. So it's this game that they play around accountability, and it really hit home how how that is so against the rule of law and what we are supposed to be teaching people. So thank you so much for bringing us that wisdom and that information. I'm sure the panelists are happy to take questions later by email if people didn't get a chance. You can pass those on, I'm sure, to Rhea or Catherine, and they'll get them to the appropriate person. And I want to thank our panelists so much for being here, Lisa, Tom, and Shane, for sharing your knowledge and giving up your time to be here. It was really fantastic. Thank you all for attending. I see that our ED and 2 of my board members are here. And I know that there's people here from the John Howards across the country and other people that are interested. So thank you for supporting John Howard Week and what the John Howard Society does. It's also Black History Month. So celebrate that as well this weekend. And I know some of the provinces will have long weekends coming up. So have a busy and safe and happy weekend. And thank you again so much for being here. I see there's a lot of appreciation in the chat for our panelists. So I'll leave that up for a moment so people can take a look at that. And otherwise, have a great day.